The public watching virtually, welcome to the Strategic and Technical Planning Committee today, Monday the 16th of October 2023. For the benefit of the public, I'm Councillor Robin Cook, Chairman of this committee, and as my Vice Chairman has sent his apologies, I have invited Councillor Shane Bartlett to assist me with the running of the meeting. Thank you, Shane. The meeting is being live streamed and the recording will also be available to view on the website after the meeting. Can I remind everyone that when you are speaking, please introduce yourselves and speak directly into the microphones so that you can be clearly heard and seen. We have one application to determine today, and I will invite the case officer to present the report and recommendations. Following that, we'll invite members of the public who have registered to speak to address the committee, and each speaker has 3 minutes. Officers may respond to any matters raised as necessary. Following this, the committee members will be given an opportunity to ask questions and debate the application. Moving on to the roll call, the officers involved in today's meeting include Carol Mackay, who's the Senior Definitive MAP Technical Officer, Vanessa Penny, who's the Definitive MAP Manager, Phil Crowther, who's our solicitor giving us legal support, Elaine Tibble is a Senior Democratic Services Officer, and Matt Turnbull is a Democratic and Electoral Services Apprentice. Item 1 on the agenda, apologies please, Elaine.
Thank you. We have apologies from Councillors John Worth, Dave Bolwell, and I think that was it. Yes, it was just 2. Thank you.
Thank you. Item 2, to agree and sign the minutes of the meeting held on the 26th of July 2023. Seems an eternity ago, doesn't it? Are members happy that I sign those as a true record? Please show. Thank you. Item 3, declarations of interest. Anybody? They've read the papers, obviously. Do you have any declarations to be declared at this stage? Councillor Tony Coombs.
Thank you, Chairman. Tony Coombs, Furwood Ward. It's not a formal declaration of interest. However, the applicant, Malcolm Shakespeare, used to be a county councillor on Dorset County Council. Although I've knew him through that role, I've not spoken to him since he stood down from the council, but I did know him, so.
Thank you, Councillor Coombs. We've noted that anyway. Thank you very much. And I'm sure if anything else crops up during the debate, members will make it known anyway, so thank you. Item 4 is public participation. Elaine, do we have any other requests to speak other than what's been registered for today? No? Good, thank you. And the details of public speaking are with the agenda. So moving on to the planning applications proper, we've got one substantive item today, item 5, and that's an application to correct the Commons Register by removing land registered as common land at Knighton Common, Winfrith, Newborough. And the presenting officer on this one is going to be Carol Mackay, I believe. So Carol, when you're ready, if you want to put the details on the screen and start when you're comfortable. Okay, thank you very much.
Thank you, Chair. So this is an application to correct Dorset Council's Register of Common Land by removing land registered at Knighton Common, Winfrith, Newburgh, under Section 19(2)A of the Commons Act 2006. The site location is East Knighton to the southwest of Wool and northeast of Winfrith, Newburgh. So that's just here. The Commons Register is in paper form with written entries and a corresponding map. A copy of the paper map showing Knighton Common CL98 is shown here on the left. The digital plan is in the centre and the consultation plan is on the right. As explained in the report, during the processing of this application, it became clear that the digital version of the Commons Register did not match the official paper Commons Register, as the southern boundary was different. So this is the amended Digital Commons Register, and this is where the amendment has been made So the southern boundary of the common land has been edited to match the paper register. This modification to the digital version of CL98 has no material impact on the application. So this is an aerial photo of Knighton Common. The common land area is hatched in pink. Okay, so the common land is about 0.8 acres and consists of the field to the southeast in this area, which is partly fenced. There's also a track which bisects the common land and a verge and ditch along the western edge of the track. The track is also a public footpath, footpath 5, Winfrith Newburgh, and also serves as private access for a number of properties. This is the southwestern corner of Knighton Common, looking along the footpath with the boundary along the left, and on the right is the grass area, which is partly fenced. This is the same point looking to the northeast. And then this is to the southeast of the property Heathgate, looking back along the footpath. This is taken further north from the driveway of the property 64 East Knighton, looking east towards Oakview. And then this is looking back towards 64 East Knighton. And this is the northwest corner of Knighton Common, looking along footpaths 4 and 6, with footpath 5 off to the right, so that's off here. This is the northeastern corner of the common land, looking southwest. And this is taken from the northwest of Oakview, looking along the eastern boundary of Knighton Common. This is just a little bit further to the southwest of Oakview, looking southeast along the eastern boundary again. This is from the same point, again, looking northwest. This is the southeastern corner of Knighton Common, looking along the eastern boundary. And this is from the same point, again, looking southwest along the southern boundary of Knighton Common. So the application was received in June 2022, and the consultation was carried out ending in January 2023. Consultation responses were sent to the applicant, who had an opportunity to reply. The representatives then had an opportunity to respond to the applicant's reply with several further rounds of comments and responses between January and July 2023. The applicant sent in additional evidence in May 2023, which consultees were also allowed to comment on. All responses from the applicant and consultees are summarised in the report. Several issues and concerns have been raised throughout the process by the applicant and consultees, which are discussed in the report, and I'll now briefly cover. So firstly, with regards to land ownership, the application was submitted with the plan on the left, showing Knighton Common, and stating that the applicant owned the application land. The applicant then later stated the application related solely to land in his ownership. So as you can see from the plan on the right, Knighton Common is registered to 4 owners, including the applicant. The evidence submitted by the applicant relates to Knighton Common as a whole, rather than just the part owned by the applicant. So officers believe the whole of the application land, CL98, should be considered as submitted to it. However, under the legislation, the applicant may be granted in whole or in part. The registration of CL98. So the application says that the land was registered as common in 1968, and the reason that no objections were received was the council did not inform the legal owners of the land at that time. However, under the 1965 Act, the council did not have to notify the legal owners of the registration, so no mistake was made. The applicant believes that the wording of the 2006 Act does not impose any restriction on the type of mistake that can be corrected under Section 19(2)(a). However, the application does not present sufficient evidence to back up this view, and officers believe the application does not meet the legal criteria. The applicant states there are no rights of common registered to the application land, and that therefore there's no benefit to the public. Under the Countryside and Rights of Way Act 2000, the public do have access to registered common land and therefore to the application land. The lack of rights of common carries no weight in considering an application under section 19(2)(a). The applicant believes that the application land was not subject to manorial rights before it was registered as common land because it was owned by the Weld estate, so could not be classed as unoccupied or uncultivated. Officers do not consider land ownership relevant in considering if the land is manorial waste. In addition, whether the application land was classified as manorial waste is not relevant to the consideration of the application under section 19(2)(a). One of the concerns raised by the applicant is that the designation of the land as registered common is detrimental to his use of the land, as he's unable to put new fencing up, so it's therefore vulnerable to fly tipping and access by travellers. Some of the objections to the application also raise concerns regarding the existing partial unauthorised fence. The effect of the designation of the land as common cannot be taken into account. The issue of fencing is not relevant, but advice on this matter has been given to the applicant and representatives in the report. The applicant submitted a copy of the Wimfrith Newburgh Parish Survey and Notes with the application and suggests that if there had been rights of common in existence when footpath 5 was added to the definitive map, it would not have been necessary to add a new right-of-way, as the public would already have rights to walk across the land. However, the public did not have rights to access common land until the Countryside and Rights of Way Act 2000. So the suggestion that footpath 5 would not have been added to the definitive map if rights of common were in existence is incorrect. The applicant submits that the Wimfrith Heath Act 1957 should have extinguished rights of common from Knighton Common, and this would have made it impossible to register the land as common in 1968. The Wimfrith Heath Act extinguished certain common rights in the area that was to be used by the Atomic Energy Authority as a nuclear research site. The application land was not included in the Act. Whether the application land should have been included or not does not affect the determination of the application under section 19(2)(a). Two previous applications submitted to the Council to correct the Commons Register by removing part of Lye Common have some relevance to the application at Knighton Common as they relate to the scope of section 19(2)(a). The applications were granted by the Council but subsequently quashed following a challenge by the Open Spaces Society. The Council later accepted the Open Spaces Society position that section 19(2)(a) only allowed mistakes of the Commons Registration Authority to be corrected. Officers believe that compelling evidence is required for a wider interpretation of the section, and this has not been provided by the applicant. Members will be aware that a letter from the applicant's agent, Mitchell Moores, was circulated last Thursday and raised the following points. Ownership of land has been discussed earlier in the presentation. The recommendation and scope of section 19(2)(a) will be dealt with in just a moment by Phil Crowther. Rights of common and public access. So under the Countryside and Rights of Way Act 2000, the public have access to registered common land except for within 20 metres of dwellings, as indicated on the plan on the left. This does not affect the registration of common land and is not relevant to the application under section 19(2)(a). With regards to copies of documents, all evidence is on the case file and is available to members and have been referred to as background papers in the report. Phil is now going to cover the points raised on recommendation and scope of section 19(2)(a).
So in terms of the scope of section 19 of the Act, officers' advice to you is that it only concerns a mistake of the authority in dealing with the application itself. So in some way not registering what had been applied for. So officers' advice is that this application falls outside the scope of those powers. And that follows Council's advice that we'd had in relation to a previous application. But nevertheless, officers have gone on to consider the merits of the application in the event that that interpretation does or may be considered to be too narrow. So in effect, you've got officers' advice not only that it's outside scope, but that even if it were, that the evidence would not support an application under Section 19. And then moving on to the way in which the evidence has been presented, as Carol mentioned, all the papers, as you'll know, will have been available to you as part of the case file and are mentioned in the report as background papers. And there's a criticism from the applicant's representatives that the evidence should have simply been presented to you with no comment and no recommendation. As you'll be aware from dealing with these applications in the past, officers' role on applications such as this is to consider the evidence that's been presented, to outline it to you and to reach recommendations on it, leading to a final recommendation to you. And also, as you'll be well aware, that you're perfectly entitled to reach a different conclusion from that recommendation if you feel you've got proper grounds. Thank you.
Okay, so the recommendation is that the application to correct the Register of Common Land by removing land registered at Knighton Common is rejected and the register remain unchanged. Officers believe the proposal does not meet the legal criteria set out under Section 19(2)A of the Commons Act 2006. Even if officers are wrong on that point, they do not consider the applicant has provided sufficient evidence to demonstrate that the application land was not common land at the time of registration, so that a mistake was made in registering it under the 1965 Act. And consequently, the application land should remain registered as common land. Thank you, Chair.
Thank you very much, Carol. We've got 3 people registered to speak on this one, and you have 3 minutes each. And I think you've been shown how to use the microphone. So when you're ready to speak, I've got, in no particular order, but I've got Mr. S. Leakey as the first person on my list. Mr. Leakey, you'll have 3 minutes, and if you press, when you're ready to start, press the speak button, and off you go when you feel comfortable. Thank you.
Hi, I'm Stuart Leakey. I'm a chartered surveyor. I live at 1 Gibraltar Cottages. On the 1st of May, we wrote by email notifying the council of the existence of the tithe map and deed for the area. Mr. Leakey to Carol Mackay. It just shows Knighton Heath, including the tongue of land in question, was owned by the parishioners of Winfrith and East Knighton. Evidently, this had been lost for some time, as it led to a series of errors in 1968 to 72, which in turn led to the re-registration of this tongue of land as common. In 1972, the tongue of land entrance to the heath was placed into the Commons Register after an application by Mrs. Killenbeck, because it was ruled there was no owners. However, the tithe map proved this to be incorrect. Is this quorum aware of any evidence that the parishioners of East Knighton and Winfrith Newborough sold this land? Else it is clear evidence the mistake was made. The tithe map shows this land in question was owned by the parishioners and the rights of common over it was their sole privilege. The brief history of the heath is in response to the first Enclosure Act in the 1700s, the people were fearful they would no longer be able to reap the benefits of the land they required for their livelihoods. This ultimately led to the creation of the common known as Knighton Heath. Indeed, the common land was known as Knighton Heath was preserved in the later 1837 Enclosure Act and detailed it as some 80 acres. When we look at the tithe map of the same period, we can clearly see this belonged to the parishioners of Winfrith Newborough and East Knighton. Thus, it is clear this land has never been manorial land, rather it was preserved for the parishioners' privilege. Here we see the second mistake. Mrs. Killenbeck was not a parishioner, therefore had no rights to common the land. We now come to the more ambiguous point where the 1957 Winfrith Newborough Act actually extinguished the rights of common over the tongue of land. The text of the 1957 Act clearly states all rights of common are extinguished from the entire heath, including the entranceway. However, ambiguity creeps in as the accompanying map cuts at the head of the lane, not extending to the tongue of land in question. However, we must consider this with some thought. The proceedings of the 1957 Act held in the National Archive contain a number of receipts to the parishioners who were compensated for their loss of their rights to common. This shows no rights shows the right to common was extinguished over the whole heath. Further, upon application of common sense, there were no fences, so should this tongue remain common land, how would they have prevented the movement of livestock? It seems clear the rights of common over the whole heath, including the entranceway, were to be extinguished. However, the UK AEA only extended its management boundary to the top of the lane, hence the map, probably as they did not want the burden of maintaining access to the properties. The extinguishment of the common rights over the entire heath, including the entrance, is further supported as none of the parishioners are listed as having any rights to common the land. Perhaps more interestingly, the receipts to their compensation within the proceedings of the 1957 Act clearly state compensation for the loss of common rights, not the right to the land. Hence, ownership must have been maintained by the parishioners. So here we see a clear mistake. Thank you.
Spot on. Thank you very much indeed. And following that is Mrs. Leakey. Same for you. Okay, thank you. When you're ready.
Thank you. I'm Mrs. Leakey of 1 Gibraltar Cottages, also a local GP. The report we find does not contain all of the evidence submitted, and there are mistakes deriving from the ambiguity of the boundary and the geospatial definition of ownership of the land in question. Additionally, the crucial evidence, the tithe map and deed, is missing in entirety from the report. This clearly shows evidence of ownership and consequently the mistake of the registration authority in registering the land as common. It is concerning that conclusion of insufficient evidence given in section 13.4 and 13.8 has been drawn when clearly not all evidence has been considered. Section 6.28, the government guidance, acknowledges that if a mistake is made by the registration authority, the register can be corrected. Section 3.4 states that the land has no registered owner and was referred to the Commons Commissioner in 1972. The Commons Commissioner failed to find an owner. The tithe map and deeds clearly show ownership of the parishioners of Winfrith Newborough and East Knighton. Although this evidence was not apparent in 1972, it is now, and consequently this quorum has a responsibility to act upon the evidence. Section 1.3 states the digital copy has been updated to more accurately reflect the parcel of land in question. However, the opposite is true. The digitised boundary of the common land is straight on the eastern side, and the northern boundary should dip to the footpath below the line of Gibraltar Cottages, as per the Winfrith Heath Act map of 1957. It appears no attempt has been made to use the evidence to reflect the boundary on the official paper copy, which is drawn at the wonderful scale of 1 to 10,560, meaning a 1 millimetre wide pencil line on a map translate to a real-world measurement of 10 metres. This seems inappropriate given the patch of land owned by 1 Gibraltar Cottages that is reputedly common is only 8 metres wide. The ambiguity of the scale will always lead to challenges, and it is inappropriate to define an area of this magnitude. Section 3.1 notably fails to describe the northern boundary. Section 6.55, the last sentence is incorrect. The Act does not stipulate the entranceway being sectioned off. The Act removes it in its entirety, but the map delineates the limit of the UK AEA's management or tenureship. Importantly, compensation was made to commoners for their loss of rights to common over Knighton Heath as a whole, but not to ownership of the land. There is no evidence that the heath or tongue of land was ever parcelled off and sold. Section 6.56, the land to the north can't have been registered as common because in 1968, the land to the north was under the control of the UK AEA, where the Winfrith Heath Act removed all rights to common. The area managed by the UK AEA is shown as being roughly in line with the southern wall of Gibraltar Cottages. Thank you. However, the tongue of land would have still been under the ownership of the parishioners of Winfrith according to the tithe map. What has been presented today has shown a catalogue of mistakes made in the process of registering the land between 1968 and 1972. The report appears to repeat this as it fails to acknowledge all evidence notified, including the tithe map and deeds. The ongoing refusal to acknowledge the evidence, along with the ambiguity and misinterpretation of inappropriately scaled maps over the decades, has led to our meeting today. Thank you.
Thank you very much. Thank you. Next speaker will either be Sarah Rhodes, who's the legal representative for the applicant, or Mr. Shakespeare, the applicant himself.
My representative, the legal representative, the firm of solicitors in Bristol.
Thank you, Chair. I speak today on behalf of the applicant, Mr. Shakespeare, in support of the application and in response to the officer's recommendations. I would like to refer to 4 key points, if I may. Firstly, I wish to register the applicant's concern with the report taken in the report. As the committee will be aware, the purpose of the report is to summarise the evidence put forward in relation to the application in an objective and unbiased manner. The Council's officers should not be making their own assessment as to the value of the evidence submitted and should not be directing you towards a particular conclusion. The report does not present the evidence in a balanced manner and should not recommend that the evidence is insufficient. The role in deciding upon the sufficiency of the evidence falls to you as members of this committee. Secondly, this is a decision which should be made on the documentary evidence. All the relevant evidence provided supports the applicant's position that a mistake was made. In particular, we refer the committee to the removal of rights of common over the adjoining lands at Knighton Common by the Winfrith Heath Act 1957, which shows that rights of common should have been removed over the whole of Knighton Heath. No relevant documentary evidence has been provided by the objectors to demonstrate the contrary position. There is no basis for the officer recommending that there is insufficient evidence to support the application. In fact, the report should have said there is some evidence in favour and no evidence against. Thirdly, the report does not dispute that a mistake was made at the time this land was registered as a common. Instead, the officer contends that the type of mistake does not fall within the scope of Section 19(2)A. The report does not provide any rationale for interpreting the statute this restrictively and relies solely upon non-legally binding government guidance. The case of Lay Common, referred to by the Council's officer, relates to a completely different set of circumstances and cannot be definitive evidence of any interpretation. This restrictive interpretation unfairly denies the applicant the means to correct what amounts to an obvious mistake on the register. Fourthly, it is important to note the level of public access to the application land. There are no rights of common listed on the Commons Register. The report is presumably referring to the public's right to access the land under the Countryside Rights of Way Act 2000. However, under that Act, there can be no rights of public access within a 20-metre distance of neighbouring dwellings. The area of land here is 0.8 acres in total and surrounded by residential dwellings. So if you apply the 20-metre rule to the application land, that would leave a far smaller area than 0.8 acres available. The land would be unusable by the public for any form of recreational purpose whatsoever. It is for these reasons we submit you should reject the recommendations in the report and remove this land from the Commons Register. The registration was an obvious mistake, and retaining the land as a common has no obvious benefit to the wider public. I thank the committee for its time.
Thank you very much indeed. Thank you. That concludes our speakers for this application. Phil, did you want to come in to me with anything? Yeah. Carol, do you want to respond to anything that's been raised?
I think that all the points have been already covered in the report or in the presentation, so I don't have anything further to add.
Phil wants to make a point. Our solicitor wants to come back on this one.
Thank you, Chair. Just to say one thing of one of the options that is available to members in determining the application, just to be so that you're fully aware of the options that you have, albeit I'm going to preface what I'm going to say with officers don't consider that this option would be appropriate, but I think it's important you're aware of it. So your options are to accept the application contrary to the recommendation, refuse it in line with the recommendation, or you could defer your decision pending a public inquiry, which the council would arrange, and then the inspector would produce a report which would come back to you to determine. So it would be in format terms very much the same as the report before you today. Public inquiries we'd normally hold a public inquiry if there was a conflict in the evidence before you. I don't think officers do think that there's any conflict in the evidence. It's a question of, is the evidence that has been put forward sufficient to satisfy the statutory test? So clear steer is from officers that a public inquiry is available but wouldn't be appropriate for this application. Thank you, Chair.
Thank you, Phil. That's very helpful. Thank you. Right, it's over to you, members. We normally try and split it into questions first and then move into debate, but sometimes the two get a bit clouded, so I'm quite happy if we continue to debate it following if you've asked a question. Can I just remind you to state your name and your ward, particularly for the benefit of those watching on the live stream. Thank you. Who's first? Councillor Rideout.
Thank you, Chairman. Councillor Belinda Rideout, Gillingham Ward. Can I just have clarification, please? How I understand it, as a 1965 Commons Registration Authority, we have limited powers under the 2006 Act, Section 19(2)A. We can, therefore, allowing us only to correct mistakes within the transcript of registering a common land. Can you just clarify that we cannot actually correct a mistake made in the initial Commons registration application? Thank you.
Okay. Phil's going to respond to you.
Thank you, Councillor Rideout. So in essence, the officer's interpretation of Section 19 is that it's a mistake in how the council dealt with the application. So, for example, if the application said to register a particular person and the council registered a different person as owner, or if it incorrectly registered a different area of land to the application, those would be mistakes. Officer's view is that if the council properly dealt with the application in that it registered what had been applied for, then any mistake as to any other issue would not be a mistake within Section 19. It's not a mistake by the authority that can be corrected. But equally, as I've said, if it was wider than that, then officers don't think the evidence that's been submitted is sufficient.
Councillor Coombs.
Councillor Tony Coombs, Verwood Ward. Can officers please give me a little bit more information around the validity of what's been said by the public speakers about the tithe map and how that impacts on the registration and this application, please? Because I'm finding it quite murky to see through this one.
Who wants to have a go at that, about the timing, dates? View.
Thank you for the question. The issue regarding what was or was not shown on the tithe map is not relevant to the application in the officer's view. As Phil Crowther said just now, the scope of the section under which this application has been made, officers believe it gives us scope to correct mistakes made by the authority in relation to the 1965 application to add the area of land to the Commons Register. So whatever was contained within the tithe map, which may or may not have led to that application, isn't within the scope of what we are able to consider today.
Do you want to come back on that, Councillor Coombs, or you? No. Okay. Councillor Jesperson.
Councillor Sherry Jesperson, Hill Fortune, Upper Tarrants Ward. In the same vein, could I ask for a little more clarification in terms of the confusion or the two interpretations of the 1957 Windfrith Act, that and whether or not that act included this parcel of land, because clearly some of the public speakers here have thought that it's self-evident. I'm not paraphrasing, I am paraphrasing, self-evident that it would have included that parcel of land. Could you just say a little more about that?
Well, just to reiterate what I said earlier, so the Act did not include Knighton Common, that's not disputed, but the applicant believes that it should have included it. So that's basically the summary.
Okay. Councillor Kelvin Clayton.
Thank you. Councillor Kelvin Clayton, Bridport Ward. I know Phil Crowther has gone over this, but because the applicant's legal advice said it again, could I just have clarity on the claim that officers have gone beyond their remit in making recommendations and conclusions?
Thank you, Councillor Clayton. I think my strong advice to you is that officers haven't gone beyond the scope of their powers. It's officers' role to advise you, having considered the application and the application documents. I think you would be justifiably be annoyed if all you were presented with was a list of evidence and no interpretation or assistance with that. As I've said before, and you'll be perfectly aware, having dealt with similar applications, the officer's comments are her professional view and guidance for you. If you feel that her interpretation of the evidence is incorrect or there are other good reasons, then you are, of course, as you know, perfectly entitled to reach a different conclusion from that, as indeed you have done in the past.
That's exactly why we have a legal support person, because that's self-evident, isn't it, on any planning application, in fact. But, you know, members always do have the papers available online in advance of the meeting in detail to look at. And it's when we look at the officer report that we then get the guidance or the steer or the balance, etc., that we then form our opinions on. So I think that would apply in any planning or regulatory application. So happy with that response.
Yes, thank you, Chair. I had assumed that was the case. I mean, particularly in a situation like this, which is overly technical, I think as a councillor and a lay member, I am reliant on the officer's recommendation. I was just concerned that there was a legal situation where they can go beyond their remit in recommendations. I'm satisfied with the answer.
Good, thank you very much, thank you. Any other members? Haven't got anyone else wanted to speak. Councillor Bartlett.
Thank you, Chairman. Just trying to get some clarity around the 1972 inquiry that found there was no owner of the land in question. Does it come under Section 9 of the 1965 Act and accordingly under the protection of the local authority that is Dorset Council, now Dorset Council? Does this still carry weight and is it a lawful position with regards to the land in question?
Yes, I think I must stress, actually, perhaps I didn't at the beginning, can you please make sure the microphone, when you are speaking, is very close and directed straight at you, and you speak loudly, if you can, and clearly into the mic. The sound system, the ambience in this chamber the acoustics in this chamber is not brilliant, so it is helpful. The sound is fine online if you're watching, but in the room, it isn't that good. So if you could help by trying to, I know it's difficult sometimes, the position of the mics and the position you want to be speaking, but they are movable. So if you can do that, it would be a help. So Shane, I don't know if you want to sort of go back to square one and start again. Thank you.
Apologies, Chairman. Is that better? So if I refer back to page 18 at 3.3 and 3.4, the 1972 inquiry found that there was no owner of the land in question as it came under Section 9 of the 1965 Act and accordingly under the protection of the local authority that is now Dorset Council. Does this still carry weight and is it the lawful position with regards to the land in question?
Thank you. Yes, in answer to your question, it does still carry weight.
Yes, please, Chairman, thank you. So it was just a clarification around, which I think was touched in the report, page 23 at 6.23, and on page 17, reference to it in the 2006 Act, allows authorities to keep common land registers, the new digital working copies of the working document in the digital age. If mistakes are made in the outline curtilage of any land, the fallback legal position, I take it, is the original paper copy that is archived. Any mistake made in that digital copy, therefore, does not render any common land as deregistered due to a mistake being made in the digital copy. Is that correct, please?
Yes, so the legal record is the paper document, which was on the earlier slide, and the digital copy is just the digital version of that. So editing the digital copy does not change the legal record. It's just a representation of it.
Yeah, I just come in there. I think that is quite an important point, actually. The definitive copy is the paper one in the archives, and that there is a slight change in their transposition to digital. That is what we would refer to. Is that correct? Yeah. Yes, Shane.
Thank you, Chairman. The applicant purchase of the land from the Weld estate and the deeds not declaring any common land status does not mean that the common land does not exist, and the assumption referred to at 6.8 on page 21 carries no weight with regards to probability that land in question has been deregistered. Would that be a fair assumption on that?
Yes, that's right. So when the applicant purchased the land, the Weld estate did not reveal that it was common land, and also there was I believe there was an error in the local land charge search that was carried out, did not reveal common land. However, that can't be taken into account for this application.
Okay, thank you. Any more speakers? Councillor David Took.
Thank you, Chair. Councillor David Took, Cranbourne and Alderholt Ward. There appear to be two threads running through this. The first is, was there an error made when the original land was registered? And if so, if that land, even if there was an error at that time, it was registered, are we now challenging that decision made many years ago? Or are we able to say, there may be a dispute about what happened back then, but the registration process was gone through properly and that the registration details are correct. And my belief is that if we're looking at whether the registration details that were agreed at the time, whether they're right or wrong, that's what they were agreed. And therefore, the only application to change would be there was an error made in the fine details, the map, the way it was. Is that the case, or are we looking at something? So even if there was an error back, either with the Winfrith Heath Act or with the registration of common, if that's gone through due process, is that now an established thing? Am I barking up the wrong tree there, or is that right?
Yeah, so that's a correct sort of interpretation. So we believe the scope of section 19.2a is limited to drafting errors, if you like, so a mistake that would have been made at the time. There's no evidence that happened, so the land was registered as common land, and the application we have can only deal with that limited part of the section.
I think Phil wants to come in and comment on something the officer said earlier on.
Yes, thank you, Chair. Just to make it absolutely clear in case it wasn't in the response to one of the members' questions about the Winfrith Heath Act, officers have reached a conclusion on that, but of course the applicant does contest the officer's view on that particular evidence, so that the applicant considers that is evidence which supports their application.
Any other speakers? Councillor Rideout?
Are we in comments? Having listened to everything, read the report numerous times, I believe that unfortunately we cannot rectify mistakes made at the initial registration of land in 1971 with the limited powers of this council as the Commons Registration Authority under the 2006 Act, Section 19(2)A. And I move to approve the officer's recommendation. Thank you.
So we've got a proposal from Councillor Rideout that we grant as per the recommendation on the screen that you see there. Do I have a seconder, please? Councillor Mary Penfold. Right, so we've got proposed by Councillor Rideout, seconded by Councillor Penfold. The recommendation as shown on the screen there, the application CLD 2022/1 to correct the Register of Common Land by removing land registered at Knighton Common, Winfrith, Newborough is rejected, and the Register of Common Land remain unchanged. Can we have a show of hands of those in favour, please? Those against? Any abstentions? That's 8 in favour, none against and 1 abstention. So the recommendation is carried. Members, thank you very much for that. Item 6, urgent items. There are no urgent items. And item 7, exempt business. Again, I'm pleased to say there is no exempt business. So on that note, at 10:48, thank you all again, and thank you, officers. I declare the meeting closed. Thank you very much.